Greetings, everybody. Oops. Greetings, everybody. Is this coming through? Okay, greetings. Today we're going to be going over. Here, let me get this stuff off. Right. Oh, link, that's going to be coming on just a moment. Oh, gosh, it's going to be coming on a little bit later because we're going to get through some of this. But yeah, we'll get you up there, Brian. Let me see here. I'll get the link up. Don't worry. I want to get through the intro here. What we're doing today is going to be records and record keepings from American jurisprudence. And the topic today is going to be the crimes for destruction and falsification of public records. And we're going to be looking deep into American jurisprudence, and we're going to find out actual practical applications of not just the law, but the intent of the law, how it came about, where it applies, what different laws might apply in different situations, and at what levels, so that in the practice of dealing with legal matters, we could bring common law intent and principles into it, which is what I feel is the essence of American jurisprudence. We'll be looking into Black's Law Dictionary 9th edition to be able to see definitions of words we might not be familiar with. And let's get right into it. The first part I want to get into is the one section we're going to look at before we get to the actual crimes is the ownership of public records as a trusteeship. Excuse me. Make sure the screen's centered here well on YouTube land as well. There we go. I want to make sure this looks good. Okay, so here it is. Public records are the people's records, and the officials in whose custody they happen to be are merely trustees for the people. Public records are the people's records, and the officials in whose custody they just happen to be are merely trustees for the people. So we think those are powerful words. This comes from State versus Peterson and Kent State University, 2018. So this is pretty recent here, this ruling. And we can look into the text of this case here and find. Sorry, the stream was just stuttering there. We're getting doxxed. All right, here we go. So in this situation, I like to go to Black's Law. And if we get into Black's Law, we could look, let's see here. Page 1675. And let's look up, start with the word trust. Let's see where we are here. Is this it? No, it's right here. True. Trust. Here we go. Let me see how it looks on the YouTube screen. Good. So a trust, it comes from the 15th century. It's the right, enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. So let's dig down on this and understand every word. So it's the right. You have a right. Right is something intangible, but it's enforceable solely in equity. So the right to the trust isn't enforced in a civil or in a criminal matter. It's done through equity, meaning it's awarded only force of ownership, right? To the beneficial enjoyment of property, not people, but property, to which another person holds legal title. Now, a person could be property. Actually, a person's a dead entity, so a person holding property doesn't have to be a man or woman, but it could just be a legal entity. Holds the legal title. So a title is basically an embodiment of an agreement of ownership or transfer of ownership. So in a way, let's break this down here, that a legal title is only a legal title. So we got to think about what a legal title is as opposed to strictly a title. Because strictly, when you think about a title, let's look up title exactly, because don't take my word for it when we get Black's Law open. This doesn't take very long, but this is the essence of why we're here. All right. This is really slow, but we're almost there. Lots of kinds of titles, as you can see. Here we go. Title. It's the union of all elements as ownership, possession, and custody. And we're talking about custody of records too. Constituting the legal right to control and dispose of property. Dispose of. The legal link, the nexus between a person who owns property and the property itself. So it's a legal link, something that bonds the law to a person who owns a property and the property itself. No one has title to that land. Well, it's an expression. So ownership, possession. Title is ownership, possession, or some other words to look up in relation to that. Legal evidence. Evidence is not just a fact, but a fact that can be accepted legally into that jurisdiction of a court, right? So when the court's reviewing evidence, it needs to meet the bar of the jurisdiction of that court, subject matter, etc., of a person's ownership rights in property. An instrument, such as a deed, that constitutes such evidence. Record your title with a county clerk. That's the expression again. It's legal evidence, meaning that when it comes to a court of law, the title can be presented as evidence in that situation, right? So you would think that when we're reading American jurisprudence, yeah. So then an instrument such as a deed that constitutes such evidence. So these are great little blurbs we get here too in Black's that I love. They're less common in this 9th edition, so let's read this one. It must be good. Though employed in various ways, title is generally used to describe either the manner in which a right to real property is acquired. So it's the manner how you acquire that real property, meaning like, say, for instance, real estate, or the right itself. So a title to a right. Is that where entitlement comes from? We could find out here because I'm sure it's somewhere over here. In the first sense, it refers to the conditions necessary to acquire a valid claim to land, right? In the second, it refers to the legal consequences of such conditions. These two senses are not only interrelated, but inseparable. Given the requisite conditions, the legal consequences or rights, so the requisite conditions, I guess, like jurisdiction, the court you're in, that kind of thing, legal consequences or rights follow as a course. Given the rights, conditions necessary for the creation of those rights must have been satisfied. Thus, when the word title is used in one sense, the other sense is necessarily implied. So when you say title, there's two senses of it that are not only interrelated, but inseparable. So the legal consequences of rights, right, have to be the same as the conditions necessary for the creation of those rights, right? They all have to be satisfied. It's used in one sense, it also is necessarily implied that it satisfies the other sense. So it might not make sense right now, but if you were looking at something where someone's trying to claim that one of these is a particular title or not, look at the requisite conditions. And if you can fit one side of the sense of a title, the other is implied. You don't have to necessarily be able to prove that other side. So some pretty interesting things to look at like that. But we got to get back to the word we were searching, because we want a better, well, let's look at equitable title, because it's right here too. And that's even closer, 17th century. It's a title that indicates a beneficial interest in property and that gives the holder the right to acquire formal legal title. Before the statute of uses 1536, an equitable title was enforceable only in a court of chancery, not of law, and that's the essence of equity and court of equity. If anyone wants to know more about that, let me know, but I spoke about that in the last live stream, so we could always refer back to that. But it will come up from time to time, so things like equity are almost a term of art. Depending on the situation you're in, it might have a very precise meaning that differs from another situation. But that's just my opinion on that. Let's get back to the matter here. Okay. Let's see here. So we're on to public rec. Now let's reread this now with this new insight of what... I'm sorry, we didn't finish with trust. Now with a better insight of title, when we look at trust, it's the right enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. And remember the title, right, is that right to the property. Property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party. Could be more than one here, right? The beneficiary. Now, settlor could be also an entity. One person is one entity. And for a trust to be valid, meaning having value, it must involve specific property. Specific. Reflect the settlor's intent. Who is a settlor? The settlor, right, is the one that requested this, right? It's to be held at the request of the settlor. Let's read this again. This is complicated, but this isn't rocket surgery. Anyone can understand this. For a trust to be valid, it must involve specific property. I think we can get this part easily. Reflect the settlor's intent. Now, the settlor is one requesting this trust, right, to be held. Is this the intent? Is the settlor intending this specific property, right? To his intent to be created for a lawful purpose, not legal, a lawful purpose. These are heavy distinctions. Depending on your jurisdiction, they might not want to define it as lawful because they'll try to make it as it's not legal. But they may not be able to override this because of the nature of this. Remember, this is dating back to the 15th century, and we're going to come up with tons of cases on trust. But we're not going to get lost in the weeds any further, I promise. Again, for a trust to be valid, specific property must reflect the settlor's intent and be created for a lawful purpose. Nowhere in here do I see anything about the trustee or a beneficiary. Do you? So for it to be valid, it must involve property and a settlor's intent. And how can you reflect a settlor's intent? It's not specified, so this is your document of a trust, I believe. Again, this is strictly for entertainment. I have no legal advice or knowledge to disseminate here. This is only for general review of American jurisprudence and some of the definitions in here, and not to be construed as legal advice in any way, shape, or form. And do not do this at home. Let's proceed. So basically, the two primary types of trusts. Now that we know that the two, I guess you'd say, elements to make it valid: specific property, Settler's intent. I say hello to Dogma. Are we still online here? Make sure all these little things are working. Looks like it is. Excellent. Okay, let's continue. The two primary types of trust now. We've got the lawful purpose and settler's intent. Actually, three things in specific property. Now we have two types of trust: private trust and charitable trust. Wow. See below. I'm sorry, but we have to finish this at least. Equitable trust, equitable duties to deal with it for another's benefit. We right here, hang on a second. Oh, okay, I'm sorry, this is it too. A fiduciary relationship regarding property and charging the person with title to the property with equitable duties to deal with it for another's benefit. This is another definition of trust. A fiduciary relationship regarding property and charging the person with title to the property with equitable duties to deal with it for another's benefit. Now that's a mouthful. We're not going to dive too deep in every word on this one because we did it for the first definition. Just to give you a process of how to do this. The confidence placed in a trustee. Really low? Check. You're right. Thank you. You're doxing me. Damn right. I can't believe that shit. All right, now it should be really loud, right? Check. YouTube says there's one viewer now. I drove everyone away. I'm being doxed. All right, let's see here. I think everything's going good now. Wow, I guess not too many people like Black's Law, but these are, to me, this is pretty important for people to know because I hear these words like trust and trustee pop up a lot, and without having very distinct, sharp, deep definitions, there's certain redundancies in here. There's certain depths of dimension that make it so that there's things that you're going to get out of here that you'll literally be able to synthesize an understanding of a trust better than anything you could read from a cookbook approach. Let's continue. Again, this puts you in a category that's probably more time than even the best Esquire spend digging deep into understanding the intent of a legal sense of what's going on here to really bring it aligned with the law. And that's kind of another concept of common law, is the reason, the intent of these written codes and laws and statutes and rules. Hey, you have rights, cops have duties. Indeed, it is important. All right. Pardon me. Okay, let's continue here. One more time. This is the second definition. I'm not going to dig deep into this because this is a more modern one. And these words like fiduciary, you need to look up in this book here because that's what it's referring to. Equitable, and that's another rabbit's hole. Confidence, charged. There's a few words in here that are very important to look up the meaning of, specifically where it applies to this. But there's too many for this live stream for this word here. But just to think about the intent of this definition here is something to consider. A fiduciary relationship regarding property. And charging the person with title, that's the trust. Remember what the title was, that's what Doug spent too much time on, but that's basically the instrument so that the rights are constructed and are evidence of. That the person with the title, the evidence of it, right, to the property with equitable duties to deal with it. Now what's equitable duties? That's another rabbit's hole. For another's benefit. So it can't be for the person with the title. They're not the ones that they're not doing it for their benefit. It has to be for another's benefit. The confidence placed in a trustee together with the trustee's obligations toward the property and the beneficiary. A trust arises as a result of a manifestation of an intention to create it. A trust arises, great word, arises, for legal means. A trust arises as a result of manifestation of an intention to create it. See fiduciary relationship under relationships. So the property so held, a corpus, it's a trust. Let's read this, and this is enough for trust for us. I'll zoom this in here just for this little part here. Oh Lord. Well, it's a scanned document. It's not going to look much better. Hang on one second here. Okay. One must distinguish, in countries where English is spoken, between a wide and narrow sense of the word trust. In the wide sense, a trust exists when property is to be held or administered by one person on behalf of another, or for some purpose other than his own benefit. In the narrow or strict sense, a trust exists when the creator of the trust hands over or is bound to hand over the control of an asset which, or the proceeds of which, is to be administered by another, which is the trustee or administrator. I like this, the trustee or administrator. So the administrator, we see this word a lot, is the trustee. Is this a synonym? I've never seen it like this before. Hands over or is bound to hand over the control of an asset, which the proceeds of which is to be administered by another, which is the trustee or administrator, in his capacity as such, for the benefit of some person, the beneficiary, other than the trustee, or for some impersonal object. Impersonal, it's not a person. Impersonal object, which would be property, right? A trust. So this is another interesting word. They don't want to say property because there's probably some other tangible thing that could be a trust could be for. Hang on a second. I'm going to take a quick break here for what we have a comment here. See if that fits on the screen. All right, I'm going to have to read it. So you have right says, administered by the public service agent or employee for the sole benefit of the people is what Nevada says. Okay. So again, you could, if you're trying to argue a point like this, for instance, you could also supplement it with things from common law and definitions from Black. So you just kind of hammer your point in, so it's very clear that what you're trying to say here is been agreed upon by people a lot brighter than me or you or this Esquire over here. Oh Lord, my stream was oh shit, getting doxxed. All right. I think I'm going to lower my bit rate maybe. It might help. I've seen my stream go out a couple times, guys. Give me 1 second. We're only looking at a book, so it should be okay. Oh, wait. Ah, shit. One thing is another. Apply. I did it anyways. All right. Never mind. Okay. Let's see here. Okay, so again, this is why we're digging into this, because when you go and make a point and someone says, yeah, but this, but what about this and this and this and this and this? Now what are you going to say? So let's continue. So impersonal object. I love this term. That's property impersonal object is even a wider category, I believe, because it includes things that we don't know that aren't property. A trust, in the sense, is a species of the genus trust in the wide sense. Wow, South African law of trust, 1985. So wait a second. One must distinguish between a wide and narrow sense. In the wide sense, a trust exists when property is to be held or administered by one person on behalf of another for some person other than his own benefit. In the narrow or strict sense, a trust exists when the creator of the trust hands over or is bound to hand over the control of an asset, which the proceeds of which is to be administered by another, the trustee administrator, in his capacity as such for the benefit of some person, the beneficiary, other than the trustee, or for some impersonal object. Are they saying it can actually, the beneficiary could be an impersonal object too? So they're not talking about the property. Wow. So that's the in the strict sense. The creator hands over, is bound to hand over control. It's just an asset. So this is strange. Proceeds of which is to be administered by another. So deep. Some courts of legal writers have defined a trust as a certain kind of right that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has in the trust property, thus looking at it from the point of view of the beneficiary. While it's true that the beneficiary has the right or interest described, the trust is something more than the right or interest of the beneficiary. The trust is the whole judicial device. The trust is the whole juridical device. Juridical means within the legal sense. We looked this up on another stream and also got the pronunciation correct. Juridical. The trust is the whole juridical device, meaning the legal relationship between the parties with respect to the property that is the subject matter, right? So subject matter, jurisdiction has to apply to this property here, right? Including not merely the duties that the trustee owes to the beneficiary and to the rest of the world. I hope everyone caught this part. Not merely the duties a trustee owes to the beneficiary and to the rest of the world, but also the rights, privileges, powers, and immunities that the beneficiary has against the trustee and against the rest of the world. Wow. Let's read this again. The trust is the whole juridical device, meaning that this trust is really has everything you need when it comes to the law and the application of the relationship between the law and the property here. This is pretty deep here. I didn't think it was going to be even this deep just to look up one word. The legal relationship between the parties with respect to the property is its subject matter, including not merely the duties that the trustee owes to the beneficiary and to the rest of the world, but also the rights, privileges, powers, and immunities that the beneficiary has against the trustee and against the rest of the world. So that's interesting there too. Beneficiary has against the trustee and against the rest of the world. It would seem proper, therefore, to define the trust either as a relationship having certain characteristics stated in the definition, or perhaps as a juridical device or legal institution involving such a relationship. That's in the law of trusts. Let's continue because I think this is it here. In the strict sense, traditional sense, a trust involves three elements. Oh, finally, something we could use to sum up everything we've read. A trustee who holds the trust property and is subject to deal with it for the benefit of one or more others. I love it. That's great language right here. One or more others. Very ambiguous or vague intentionally. One or more beneficiaries to whom and whose benefit the trustee owes duties with respect to the trust property. And 3, trust property, which is held by the trustee for the beneficiaries. In a more comprehensive sense, the trust purpose is often included in discussions of the elements of the trust. Although all of these elements are present in a complete trust, either or both of the elements 1 and 2 above may be temporarily absent without destroying the trust or preventing its creation. Wow. All right, so this is a deep dive into trusts here really quick. Yeah, those juridical courts. Juridical. Now you got me going. Why'd you have to spell it that way? Juridical. Officer safety is a whole nother. There's a whole nother section we can get into with probable cause in American jurisprudence that would really can dig really deep into that aspect, and I'm gonna plan to do that another time. I wanted to kind of dig into this because there were people that were asking about destruction of public records and the crimes associated with it. But before we can even get into something like, thinking about the accusation of crimes, we want to have a deep, deep understanding of this because you can see some of these themes that keep resonating here with trust and respect, duties for the world. How do these things creep in here into a word like trust in a juridical sense? In that a trust is a juridical device. It's the whole juridical device when it comes to that connection between property and this agreement, right? So we had another term we learned in here was, what was his name? There's another person in here. We have a settlor. So this is one for your number 7 Esquire pen, a settlor. It's at the request of another, the settlor. Again, this goes back to 15th century. So when you talk about stuff like that, if they say it's deprecated or has become obsolete, there would be a point in time in the case law where you could see where it has become, but I don't think so because this isn't a very broad sense, right? A property interest held by one person, the trustee, at the request of another for the benefit of a third party. So I think everyone should be very clear to understand this interpretation because this is 15th century. This is where it comes from, and everything else has been a journey from this. And when you see the journey it's taken through American jurisprudence, the term itself, jurisprudence, should imply that it is something that has been taken with a prudent approach to justice. And that's why we see the evolution of these terms, hopefully not a perversion, which we've been seeing in more recent times. Let's continue here now. I think if we have a good idea of trust, I want to get to trusteeship. So let's get to that exact definition because that was the definition we were looking for. But by understanding the root of the word, because it is a very complex issue, it's going to help us understand trusteeship. Custodial trust. A revocable trust for which a custodial trustee is named to manage the assets for an incapacitated or disabled beneficiary. There are all kinds of great trusts here. Destructible trust can be destroyed by the happening of an event or by the operation of law. Directory trust, a trust that is not completely and finally settled by the instrument creating it, but only defined in its general purpose and to be carried into detail according to later specific directions. See fixed trust. And we go down here to see what a fixed trust is. A trust in which the trustee may not exercise any discretion over the trust management or distributions. Also termed directory trust, non-discriminatory trust, discretionary trust. So we could go on with trust all day long. We need to get to trusteeship if we could ever make it that far, which is a problem with these kind of dictionaries. If anyone thinks that the rabbi trust slaying irrevocable grantor trust whose assets remain subject to the claims of the grantor's general creditors, and from which benefits are paid to the grantor's employees if a stipulated event occurs. Gosh. A rabbi trust is a form of non-qualified deferred compensation plan. So deferred compensation is when they take money out of your pay to pay you later because they're going to invest it in something. Because the trust can be reached by creditors, the participants can avoid being taxed on the constructive receipt of the benefits held into trust. Its name derives from the IRS letter ruling that approved its use by a synagogue. Right, we're all still here. Making sure I'm not getting fully doxxed yet. The trusts go on forever. Voluntary trust. Trust that is not founded on consideration. One having legal title to property may create a voluntary trust by 1, declaring that the property is to be held in trust for another, and 2, transferring the legal title to a third person who acts as trustee. 2, an obligation arising out of a personal confidence reposed in and voluntarily accepted by 1 for the benefit of another. Voluntary trust. Voting trust. Trust. Love trust. Trustee. Trusteeship. Let's see if the word actual trusteeship is in here, and we'll come back to trustee. Trusteeship. Sure enough. A trusteeship, the office, status, or function of a trustee. In international law, is administrators or supervision of a territory by one or more countries, especially under UN trusteeship. Wow, mandate. Trusteeship is the office, status, or function of a trustee. So we went through all that to find this definition out, which probably would have sufficed for our purposes, but I believe this little journey down the rabbit's hole will benefit us all later. I call it latent learning. It should be a waste of time, hopefully. Let's continue. Now, we haven't even really gotten started, so if you came late, hit the thumbs up, and we're going to get started right now into the actual crime portion of it. This was just the part to get everyone warmed up and on the same page as far as where we're going to be going. Because we don't want to leave, my whole thing with this is to leave no word behind. So let's continue. All right, so 1129 is where we left off last time, and this should be it. So we're going to start with the federal crimes for removal, destruction, or falsification of public records. So first part, we're going to talk about the federal crimes, then we're going to talk about the state crimes, and then we'll continue down until it gets to the point where people are heard enough about public records. And then we'll continue again, because this has so far been, I think, part 4 of the records and record keeping series of American jurisprudence. And we're not even like a quarter of a way through it. Let's continue. A federal statute makes it a crime to conceal, remove, mutilate, or falsify a record deposited within a United States office, such as the post office or officer. Thus, a Merit Systems Protection Board could properly find that the backdating or replacement medical records and an attempt to pass off these replacements as original documents constituted a falsification of medical records under the statute because the consultation sheets that the defendant produced were knowingly false with respect to both the date and the physician's signature. And the defendant used them in a willful attempt to deceive a third party in order to protect himself. So we're getting right into it here. Again, when we're talking about these federal statutes, it probably doesn't apply to a lot of things that we get involved with, except for the post office. But there are some that are still dealing at that federal level. This is helpful to know. Backdating and replacement, not just medical records, but anything to falsify, mutilate, or remove, conceal. These are crimes. They're federal crimes. So there's systems, there's a Merit Systems Protection Board. I never knew this existed, but there it is. So a practice tip. One of my favorite things here in American jurisprudence is these practice tips, because this is where the rubber meets the road of everything we're learning. Let's listen to this one. The amount of loss attributable to a defendant's unlawful concealment, removal, and mutilation of government records under the statute for sentencing purposes is not limited to the nominal value of the sheets of paper actually destroyed by the defendant. Pretty simple concept, right? That sheets of paper, I can only be, liable for this much money for destroying the documents, for concealing them or whatever, mutilating them. It's not just the price of what you mutilated. It's not limited to their nominal value. Another federal statute makes it a crime to knowingly embezzle, steal, purloin, convert, or without authority sell any record, voucher, money, or thing of value of the United States, or any property made or being made under contract for the United States, or to receive, conceal, or retain it, knowing that it has been embezzled, stolen, purloined, or converted. Yet another federal statute makes it a crime to feloniously steal, take away, alter, falsify, or otherwise avoid any record, writ, that's a written order from a court, a process, or other proceeding, like a service process when they're serving you a summons, or other proceeding. Those are the actions of the court in any court of the United States, whereby any judgment is reversed, made void, or does not take effect. So there's crimes involved if you're not getting a fair shake at a federal trial. How many people are still in this? All right, we got people here still. Making sure I'm not totally shadow banned. What's going on here with my chat thing? There we go. Beautiful. Yeah, good. Gotta be careful. Yeah, because we all get, you gotta be very careful there. What I'm learning here, and the reason I'm doing all this stuff is because of that very reason right there. And I find that the better you know this stuff and the more ways you can go about it, less road rash you'll get when the rubber does meet the road. All right, let's continue. Federal statutes also prohibit officers or employees of the United States from knowingly compiling or issuing false statistics or information relating to the products of the soil as a report of the United States, and prohibit officers, clerks, agents, or other employees from making false or fictitious entries in accounts or records of any kind with intent to deceive, mislead, injure, or defraud. Yep. In addition, it is also a federal offense for anyone to knowingly issue or publish any counterfeit weather forecast or warning of weather conditions falsely representing it to have been issued or published by the Weather Bureau, United States Signal Service, USS, or other branch of government service. A federal statute makes it unlawful for any person to make or submit any false record or account of any fish, wildlife, or plant that is or is intended to be imported, exported, transported, sold, purchased, or received from any foreign country or transported in interstate or foreign commerce. If someone mails you a lobster, spiny lobster from South America, or maybe it's legal, and you get it in a state where it's not legal to have outside of season, then you're in violation of that federal statute because you just imported something from another country that's of wildlife. And if you didn't claim it when you mailed it, then you're falsifying or you didn't submit by omission or concealing the record of it. So be aware of these federal statutes, 18 U.S.C. section 2071. Yeah, exactly. That's the whole point of this stuff. Hey, Spike, you got to fix your icon. Some reason it keeps coming up blank. I've seen it some other places blank there. Not on YouTube, but on streaming software. All right, let's continue. All right, let's get back into the state crimes for removal, destruction, falsification. So state statutes may provide criminal penalties for an offense for removing or destroying public records by the actions of unauthorized persons or tampering with public records, including theft or destruction of public records or fraudulent secreting of public records. Now, this is a crime to be filed, registered, or recorded in a public office. Although falsification statute may be limited to acts specified in statutory state officer. So it seems that the penalties are for removing and destroying the crimes of them, right, are for people that are unauthorized to be with them in the first place. But if you're authorized to be with them, it's also generally a crime to offer a false or forged instrument to be filed. Well, that's still the person filing, recorded in the public office. Although falsification statute may be limited to acts by specified statutory officers. So if they're the ones that are registering or recording them, it seems here it's a crime for them. The falsification statute, so falsifying records may be limited to acts by specified statutory state officers. So if you falsify the record, it's really the onus seems to be on the specified statutory officer to ensure it's not being falsified before it's being entered into record or recorded. It is a statutory violation of false alteration of governmental records. It's a statutory violation of false alterations of government records for an officer to create a governmental record and write a false entry in it simultaneously. So if they create a record and make a false entry, it's a statutory violation of false alteration. Even though they create a false document, they can get, I guess, in trouble for the false document and for the violation. Or if they created the document properly and then made a false alteration, that's how they would still get them. So what you're looking at here is ways of people trying to squirm out of it, and if you're really guilty of the crime and the truth, that the jurisprudence is going to weed it out, and that's what this is. So this looks from both the perspective of defense and prosecution. So when you look at it from both sides, it's not biased. The problem with a lot of legal literature is biased. American jurisprudence is only biased around prudence and justice. So that's the nice thing about learning, when you're learning the law from this perspective, you're learning the legal parts of it, but from the intent of the law, which is really the intent of what humans collectively want for justice, so they could have, the secure peace that people really need and desire, I believe. So let's continue. The procuring or offering of a false instrument for filing in a public office is an entirely separate offense from falsification of a document that is already part of a record. Yeah. So, providing false information on proof of service on the back of a subpoena and later attempting to mislead a court into believing that the defendant has personally served a subpoena on a witness is sufficient to support a conviction for tampering with public records. Get this, providing false information on proof of service on the back of a subpoena and later attempting to mislead a court into believing that the defendant has personally served a subpoena on a witness is sufficient to support a conviction for tampering with public records. Observation. A statute providing that every officer who has custody of a record deposited in any public office shall not steal, remove, secrete, destroy, mutilate, deface, alter, or falsify the record, or permit another person to do so, or so does not make it a crime. Oh shit, let me read this. So, alter, falsify the record, or permit another person to do so, so does not make it a crime for any person to steal, remove, secrete. So it's a statute that means that every officer who has custody shall not do this, cannot be used against any person. So if you see a statute in your state, this is what the observation's about, because American jurisprudence is general. It's across everywhere in America, and state statutes may apply in certain situations, and you have to be aware of it before you come up with any kind of legal strategy to a case. So a statute providing that every officer who has custody of a record deposited in any public office shall not steal, remove, secrete, destroy, mutilate, deface, alter, or falsify the record, or permit another person to do so, does not make it a crime for any person to do these things: steal, remove, secrete official government documents. So if any person does, so I guess it comes down to that officer who has custody. If someone in the office does this kind of thing, that this person cannot actually fall a crime under that statute. It'd have to be a different crime. So you have to be very careful that you don't try to prosecute for the wrong crime, is what they're trying to say here. And here you go. You get your number 10 footnote for that one. Just for instance, that's 2015 Association for Los Angeles Deputy Sheriffs versus Los Angeles Times Communication. So that meant that they were trying to get someone in trouble for doing one of these things: stealing, removing, secreting, destroying, mutilating, defacing, alter, falsifying, or falsify the record. And it seems who won? Number 10? Yeah. We'll have to find out on that one. We're not going to do that right now. All right. Whew. Public records within state laws regarding removal, destruction, or falsification. So what constitutes a public record or document within statute making? So this is where we're at. All right. To be a public record within the meaning of a statute prohibiting the alteration, defacement, destruction, removal, or concealment of a public record, the official books, papers, or records must have been created, received, or used by the state or any agency of the state and kept, whether on a manual or automated basis, by the state governmental agency creating, receiving, or using them. All right. You have rights has a good point here. I guess I have to read it because it is long. I figure a way to make this thing look bigger. Whenever someone is being arrested for the wrong reasons, it is because public service agents, public official servants are using statutes overbroad of the intended usages of that statute. And yeah, if they're being arrested for unlawful reasons, it's typically in that way. Question is, how do you stop them? We have a American jurisprudence that I'd like to go over at another date too. That probably goes over some, I don't know, some pretty interesting ways we may be able to resolve this in a amicable way in the field in the future. And I think I've discovered something that might work, but I don't want to digress too far from that tonight. Let's continue. All right. The fact that a form is not necessary does not negate its existence as a form kept by governmental entity, so as to constitute a government record within the meaning of tampering with record statute. So the fact that a form is not necessary. So I think we've found some examples, in fact, with Audit Them. Is Audit Them still out here? Leg on leg, there he is. So interesting enough, there's a great audit. If you got to go to his channel, you can put up your link if you want there, Audit Them. I think you can do that. If you notice on his channel, there's a great video there where he went into the police station and they're insisting he use a standard form to make a public request. And he pointed out that there's a statute that states that there is no standard form required. But that, yes, he actually stated first that yes, that you guys may have created a form and have a form on file, but it's not required, which is true. And here we get right in American jurisprudence, the fact that a form is not necessary does not negate its existence as a form kept by governmental entity, which he was right too, so as to constitute a government record within the meaning of tampering with record statute. So if this record is there and someone starts making changes on the record or blocks out certain issues of it, well, then they're tampering with that public record, even though it's a form and even though it's not necessary. Forms, by the way, may change over time, is why they are kept control of with what's called a revision status, a version status of that document. And that version status needs to be kept in a master index so that whoever's responsible for maintaining the distribution of those forms or documents can make sure that the people at the point of use can only access the most current version or revision of that document or form. And it needs to be clearly noted so that the custodian or whoever is responsible for maintaining the distribution of those documents is aware of the revision status so that the documents can be effectively controlled. Let's continue. Even a document not considered a public record under a Freedom of Information Act may fall within the protection of a statute proscribing tampering or destroying public records. So when you think about this, even if it's not a public record and they're destroying or mutilating or modifying or all these other things here, it could still fall under a crime of tampering with a public record or destroying a public record. Documents that are not open to inspection by the public may not be public records within the meaning of statutes setting out certain offenses relating to the misuse of public records. But there is authority holding that the fact that a document is not open to general inspection by members of the public does not, in itself, mean that the document is not a public record subject to such a statute. By the latter view, the nature of a public record is not based on the public availability, but on whether a public body prepares, owns, and retains the record. So we find that, always in small print. Guys, you got to read the small print always. We're doing the small print tonight, even the black slide. I got to get a better scanned edition of that. So the documents are not open to inspection by the public. See, this gets confusing, but what this is doing is setting it out that the definition of a public records is wider than a lot of people want to say they are. Just because they're not open for inspection does not mean that the document's not a public record and subject to a statute. And by this view, the nature of a public record is not based on the availability of the record, but on whether a public body prepares, owns, and retains the record. So even if it's not open to inspection, doesn't mean it doesn't have to be maintained by them. And it's not based on a public availability of the record itself, but we need to have proof as a public when we're auditing them that they still have that document there. The contents of the document perhaps may be not open to public inspection, but it does not mean they have a responsibility of the document, and how else will we know if there's any crimes being committed of a mutilation or destruction of a document if we can't even see a record of it being kept? Let's continue. The filing or other formal retention of a document by a public official office makes that document a public record within the meaning of a statute prohibiting the forgery or other misuse of public records. The filing or other formal retention of a document by a public office, public official servant, makes that document a public record within the meaning of a statute prohibiting the forgery or other misuse of public records. So the filing or other formal retention. Understand this definition. Oh, it's not a public record. The filing or other formal retention. What's a formal retention? That's open to interpretation, isn't it? Of a document by a public office. Now, public offices don't do things public official servants do. So the POS makes that document a public record just by formal retention or filing. Formal retention. It's not even a filing. But only a public record within the meaning of a statute prohibiting the forgery or other misuse of public records, and documents that have not been filed or kept by a public office are not public records within the meaning of such a statute. Or kept. Very vague on purpose. Your other profile picture was great, but it just wasn't loading right. Spike, let's see if this one loads. Yeah, that looks actually good, man. That actually looks pretty cool. Oh, Lord. Barry says it still should be recorded right. If they retain it formally, like they say they stamp it and they say they got it, they can't modify it now. It would be a crime. That's what they're trying to tell us here. All right. So, the mere fact that a paper is found in a public office does not necessarily make that paper a public record within the meaning of such a statute. The mere fact it's just found in a public office. It has to have a formal retention. Whatever that means. It's kept. These are functioning words. Formal retention, kept. And of course, filed is very clear, but these are more vague. And this is where the law happens here. Items constituting public records under these statutes include, all right, look at the public records here, guys. These are under these statutes. And remember what statutes we're looking at? We're looking at statutes regarding state laws regarding removal, destruction, or falsification. Here's our checklist. Get your number 7 Esquire pencil out. So we got here retention. Is a freedom of information officer. Yeah. As soon as they do that, it's retained formally. That's a form of being retained. So there it is. Now, I would say I'm sorry. It's all right. You have rights. Everything's good. All right. So here's our checklist. So these are items constituting public records under these statutes for the forgery and elimination, all that. A property tax record, motor vehicle registration records, social security card, state bar admission record, a permanent residency card, court order, judge's warrant, cannot be modified as a crime, an officer's offense report being falsified. An officer's offense report being falsified. An officer's accident report. These are crimes under state statutes. Various state statutes. A controlled substance test release form. A release bond. A firearms qualification form. Campaign finance. We hear about these. Detention facility incident report. A criminal history summary in police files. So these powerful stuff. So here are things that are not constituting public records. Because if it's a fake social security card, I guess, if they do so destroy it, there's no crime there, right? It could be destruction of evidence, but it wouldn't fall under these statutes. A bid for garbage collecting franchise is not a public record. A private academic transcript is not a public record. And a paper purporting to be a birth certificate is not a public record. Now, let's think about this here. It's not a crime to do what to these 4 different kinds of non-public records, which is very strange because these are particularly removal, destruction, and falsification of these. So destruction and falsification for most of these is what we're talking about here. Falsification of a fake social security card is not a crime for for the statutes involving public records. Neither is a modification or destruction of one of these guys, or falsification of an academic transcript, a private one, is not a falsification of a public record. A paper purporting to be a birth certificate that's falsified cannot be considered a crime under a public record statute. A paper purporting doesn't say illegal, legal, lawful, true, or not. That's interesting. It's not a public records crime to falsify a paper purporting to be a birth certificate. Interesting. A cash book that was blank before a false entry was made. It's not a public record crime for falsification, destruction. And here we get a single case for each of these things. Incredible. One, I do want to see which one is it for. For the academic transcript was 27. And we got some good ones for our friends, I know, 17 and 18. Let's see where this is. 17, State, Texas. Petition for discretionary review filed 2020. Interesting to look at this case. Ratcliffe versus State, Texas. Just Austin, and the other was 27. State versus Friedman, 1988. In Florida First District Court of Appeals. Cool. That's in District Florida Reporter 303. Okay. All right, we're all still here? Yes. So we got public records within state laws regarding removal, destruction, or falsification. Express statutory authority. So what constitutes public? Okay. Records not created pursuant to any express statutory requirement or authority may be outside the purview of statutes prohibiting the forgery or other misuse of public records or documents. So if they're not created pursuant to any statutory requirement or authority, then they may be outside of any of these statutes here about the misuse or forgery of the public records or documents. Papers required by statute to be made for, or which there exists some express statutory authority, are public records or documents under such statutes. So there would be a statutory requirement for the document to exist. In other words, they're trying to say that public records do not exist for record's sake. The public records exist for a statutory authority or sake. There's going to be a statutory requirement for the public record to exist as a public record. Otherwise, it's just record. As in the case of records mandated by the statute or required by the statute to be produced. There we go. However, there is authority that it is not necessary that a record be required or expressly authorized by statute. So there is authority, which will be footnote 5, that it is not necessary that a record be required or expressly authorized by statute. And it is sufficient that the paper is useful or necessary to the discharge of some official duty. Useful or necessary. Here's your operative words, and that's footnote 5. And that's People versus Spurl. Wow, that's California Reporter, 2nd District, 1976. That was a different time. Nice to see it still holding. Again, this is 2022 we're looking at, so it's rather current. Now we're on to the nature of right to inspect public records. And I hope everyone's here because this is the part I've been waiting to get to. I feel that I'm really honored that everyone stuck with me this far because we really took a deep dive into the nature of public records in general, the trusteeship relationship that our public officials have a responsibility to uphold, and now we can get into the crimes that are committed when they don't uphold their trust. Let's continue. The common law and long established public policy to protect the right of the public to access and inspect public records in order for the public to verify government accountability, ensure the functioning of a proper democracy, ensure the integrity of proceedings, and permit checks against the arbitrary exercise of official power and secrecy in the political process. The right, however, is not absolute, requiring a balancing of competing interests. Records in the hands of public officials are subject to a presumption that they are amenable to public inspection. In other words, what happens in the halls of government is presumptively public business. Let's read this again, because this is definitely profound. Records in the hands of public officials are subject to a presumption that they are amenable to public inspection. How many are amenable to public inspection when they're holding them in the hands of these public official servants? In other words, what happens in the halls of government is presumptively public business. Define amenable. Thanks. Okay, give me 1 second. I can get there a little faster if I do it like this. And we're looking for amenable, right? We gotta look in black so we get a good, oh yeah, okay. Making sure it was in here. Page 122. Amenable, from the 16th century. It's an adjective, means legally answerable, liable to being brought to judgment, amenable to process. So it's liable to being brought to judgment. It's legally answerable, something you can answer to, right? So let's continue on the definition of it. Is there more to it? Nope. Amenable, amenability, amenable to process. That's all you get from this one. I could pull up a different edition. We'll have better stuff, but 16th century, so I don't think there's anything more to it than this. Legally answerable, liable to being brought to judgment. So something that's amenable to process is liable to being brought to the judgment. It's answerable. Okay? Legally answerable. Thank you for that suggestion there, so we could keep everyone up to date. All right, so we'll leave that on there, so if you're looking quick, you'll be able to find it. All right. Back to where we were. Sure. There we go. All right. So all right, so we're back to the any request for a public record must be construed liberally in favor of free and unrestricted access to the records, and that access can be denied only when the law specifically and unequivocally provides otherwise. Whenever there is doubt as to whether the public has a right of access to certain records, the doubt must be resolved in favor of the public's right to see. The question presented is one of law. So this is an interesting point here. Let's read this again now in context, because this is the intent of the crimes for altering. Why would it be a crime to mess with a piece of paper? because these pieces of paper are more than just pieces of paper. As we've seen, the value for the crime can't be the nominal value of the paper itself. So they have some other intangible value, and the intangible value is to the public. It's our property. Records in the hands of public officials, POSs, public official servants, are subject to a presumption that they are amenable to public inspection, legally liable to public inspection, legally liable, answerable to public inspection. In other words, what happens in the halls of government is presumptively public business. Any request for a public record must be construed liberally in favor of free and unrestricted access to the records, and that access can be denied only when the law specifically and unequivocally provides otherwise. Whenever there is doubt as to whether the public has a right of access to certain records, the doubt must be resolved in favor of the public's right to see. The question presented is one of law. Federal and state statutes codify the right of public access to and inspection of records. And state law favors access to public records. So there's federal and state statutes that codify the right of public access to and inspection of public records. And state law favors access to public records. So if you have an issue with just access, then perhaps your state laws might have the answer there. Let's continue here. State statutes are construed liberally in favor of broad access. Any doubt is resolved in favor of disclosure of public records. Geez, how hard is it for anyone to understand this? State statutes are construed liberally in favor of broad access. Every word in here is telling you that there are records, and they have to always, it's like someone's holding your wallet for you and say, can I have my money? And they're like, well, no, I'm not sure I want to give it back to you. It's like, I gave you my money. You're getting paid to hold my money. I want my wallet back now. Any doubt is resolved in favor of a disclosure of public records, then limiting exemptions to their stated purpose, and the statutes cannot be construed as affecting in any way the common law right of access. Jeez. 13, 14, 15, and 16. You got to look at this before I go nuts. Freedom of Information Acts, of course, we'll refer to that on another session. Morgan and Morgan, Mississippi Court, Appellate Court 2019 versus St. Tammany Parish. Wow, a whole bunch of cases on this one. 2005, 2008, 16, Florida, 4th District Court of Appeals. Boyle versus Town of Gulfstream. That was 16. To their stated purpose. That's in Florida. So they need a stated purpose. At least I know in Florida, anyone that's doing any kind of public records auditing in Florida, that any exemptions to your access, this is a case law here, 16 is referring to Florida. This whole this part of this sentence is especially Florida here, because it's after footnote 15. Let's read this again. So the state statutes are construed liberally in favor of broad access. Any doubt is resolved in favor of disclosure of public records. And then the only limiting exemptions is to their stated purpose. And the statutes cannot be construed as affecting in any way the common law right of access. So you can never have a state statute override a common law right of access. This is some heavy stuff. Let's continue. A citizen has a fundamental right to have access to public records. A fundamental right to have access. And the right to know regarding public records is the rule, while secrecy is the exception. See, the public wants the rules, and the ones that don't want the rules are the public official servant fools. Under this fundamental right to have access to public records, people have a right to know that the people they entrust with the affairs of government are honestly, faithfully, and competently performing their function as public servants. A citizen has a fundamental right to have access to public records, and the right to know regarding public records is the rule, while secrecy is the exception. Under this fundamental right to have access to public records, people have a right to know that the people they entrust with the affairs of government are honestly, faithfully, and competently performing their function as public servants. Important stuff, guys. This is serious stuff that we need to be aware of, because I don't hear anyone talking this talk, and as much as I know some of the laws, I never realized how deep this runs through our nation, and that our state laws are more in favor of access than even the overriding federal laws, and then you have common law that can override state statute if it isn't good enough. And we all have case law to look up that's all referenced here. The common law right of access is footnote 17. Look at we got Sussex Commons Associates LLC versus Rutgers, and that's in the New Jersey 2010. Judgment reversed on other grounds, New Jersey 2012. But regardless, this is 2012. We're looking at 2022. So whatever you got to read the text. I don't know what actually happened there. But the fact is that whatever it ended up being at this year 2022, the case holding at this point, the state statutes cannot be construed as affecting in any way the common law right of access. And that I'm not sure of, but I'm sure it just means that there's even more liberally construed broad access for the people. Whew. I like this so far. Make sure you guys hit the thumbs up if you're enjoying this. The public's right to have access to public records is also guaranteed by the freedom of the press and the due process clauses of the United States Constitution and state constitutional guarantees. A claim of annoyance, embarrassment, oppression, or undue burden or expense is not enough to overcome the public's right of access to public records. The public's right to access is relevant regardless of who opposes keeping a record under seal. And this is the seal talk we're talking about here. Practice tip. The common law right to access public records depends on 3 requirements. Are you ready? This is your practice tip. This is what the Esquires spent all that money to learn, this little box right here, without going through the trouble we just did to understand the depth of the intent. 1. The records must be common law, public documents. 2. The person seeking access must establish an interest in the subject matter of the material. And 3. The citizen's right to access must be balanced against the state's interest in preventing disclosure. And then we have footnote 25, which refers to, here's our case right here, Fair Share Housing Center Incorporated versus New Jersey State League of Municipalities. Judgment reversed on other grounds in 2011. Interesting stuff to read up on there, but that's your reference to this here. This is our current case holding in 2022. So this is a good practice tip. Common law right of access to public records. Remember we were talking about this. This overrides state statutes. Cannot be construed in any ways as affecting the common law right of access. And this is it. The common law right to access of public records depends on 3 requirements. Here they are. Common law public documents. We've got to figure out if it is. In most cases it is. The person seeking access, you have a subject matter interest. Citizens' right to access must be balanced against the state's interest. Which spine is this? Public records. And this is records and records keeping is the edition we're reading from right now of American Jurisprudence. I think it might be in the description, maybe not. The title of the spine is, it is the spine. It says records and records keeping. I'll tell you later which one it is. The burden of proving that requested records are accepted from disclosure rests on the proponent of the exception. The burden of proving. It's not going to be on the people. So if you're telling me that I can't see a requested record, then the burden of proof is on you. If a custodian of public record refuses a citizen's demand for inspection of a record, the burden is on the custodian to justify the refusal of inspection with specificity. Specificity. Let me read that again. If a custodian of a public record refuses a citizen's demand for inspection of a record, the burden is on the custodian to justify the refusal of inspection with specificity. And that's 27. City of Matthews versus Voice of St. Matthews, 1974, Kentucky. So this is a long-held case. Specificity. I think just the fact if you could say this word well enough to somebody, they would probably just agree with whatever you're saying. All right, let's continue. Specificity. So cumulative supplement. This is great. So here's a story time here for a case. District Court was required to evaluate all documents in a judicial record individually when deciding motion to vacate sealing orders with respect to publicly available documents. This is a good one here, the motion to vacate your the sealing orders with respect to publicly available documents, including obituary for a doctor who performed, abortions, arrest reports available on public websites, deposition testimony, documents from the Louisiana Department of Health and Hospital, documents from Louisiana State Board of Medical Examiners, documents identifying abortion providers or staff, and incident. Okay, so this is one of those terrible, 2022. So I don't really want to delve into this particular case here because, although it is relevant if you are practicing law and these are the kind of cases you're handling, the sad fact of common law is that these recent case holdings you see here, like in 2022 in the Fifth Circuit, you're starting to see the effect of the liberal judges that are, in my opinion, seem to be destroying the essence and the intent of our common law heritage here. And little by little with these kinds of holdings, you're going to see, whether I'm not sure of this particular one or not, but the fact that it's such a recent holding compared to this one that we saw from 1974, which is something that's, which one was that? Footnote 27, and that, just so I don't cite the wrong one, the specificity, right? That if you're going to justify a refusal of an inspection with specificity, meaning they have to specify what the hell they're going to refuse you about. They can't just say we don't want to or this or that. I need specificity. And that is the burden is on the custodian. They don't need to say you got to look up somebody else. The custodian, not their esquire. The burden is on the custodian, not the esquire, to justify the refusal of inspection. And they can only justify it with specific reasons why they're going to refuse it. And it's a balance, again, as we saw here, it's going to be a balance between state's interest and preventing disclosure. And that's basically in general, although this is a common law application. Again, American jurisprudence is our way of bringing common law into our whole judicial system. So let's continue on. Great section here. And it only gets better at this point. So I really appreciate everyone that came along the other 3 parts to get this far, because the stuff we learned getting up to this point makes us very able to understand the depth of the intent of what we're learning here and how it applies to the functioning of a peaceful society that has justice, as its foundation and not violence. Let's continue. The balancing test for right to inspect public records. So here's our balancing test. See where it's best for the citizens or the state's interest when you're talking about disclosing public records. So the right of access to inspection of public records is not absolute, unqualified, or unrestricted, and may be subject to statutory or common law exceptions, including an overriding public interest and the demands of individual privacy. The right of access must be weighed or balanced against the interest in preventing disclosure, taking into consideration. So here's our checklist for balancing, right? So imagine the scales of justice, right? She's blind, holding the scale there, and on one side of the scale, we're going to have the state's interest. On the other side of the scale, we have the citizen's interest. And whichever one gets the most weight wins. That's how this case, they just said, is going to be decided, right? A preponderance, right? It says here the right of access, right? The balance of it, right, must be weighed or balanced. And they give a case law here explaining what they mean by that. So here we go. Let's see here. Okay. The type of record requested and the information it contains. So this is our checklist for balance. So what type of record is it? Some type of records might have more state interest. Some type of records might have more citizens' interest for privacy or not. You understand? So next balance test. The form in which the information is disseminated. Okay, is it already being put out all through the internet? Or is this something that they keep locked away in a vault already? So if it's already being disseminated to the public, then the balance is more going to be on the citizen side for access when they come to see it. The level of detail contained in the materials requested. You have a lot of private information there. The state has, or there might be personal or citizen privacy concerns that would hold the retention there, right? It'd be a negative weight on that side. So let's continue. The nature of the governmental and public interest as they relate to the document itself, and the general public interest in the openness of governmental process. So is this something that's a public record is really more of an indication of how government is functioning and not any kind of information that's actionable for any kind of damage or harm? So that would be on that side of the balance, right? The relative interests of the parties in relation to the specific materials in question, right? How are the relative interests of the parties? So how is the government related to the specific materials, and how is the citizens related? Are these like secret government documents, or are they people's documents that everyone's supposed to know about? Are they, like, for instance, are they water reports that everyone should know, or are they somebody's personal information? The extent to which the public had prior access to the document. Did it used to be available to the public and now they're trying to keep it secret? See, that's not going to help the secrecy side of the balance. The extent to which disclosure will impede agency functions by discouraging citizens from providing information. By discouraging citizens from providing. Oh my gosh. So like when they send those letters in the mail saying, you voted and shame on you, you didn't vote last time, then you'd say, oh my God, they're watching me, I'm going to just stop voting. See, so you could say that that's a reason why you would not disclose that information. But you have to weigh it to other reasons why we disclose voting information about your activity there. So this is how it works. It's not rocket surgery. All you have to do is a couple checklists here, and it's a balance. It's like give them values, plus or minus this or that for one side or the other, for securing the document or releasing the document. And fill the balance one by one with this. Which side gets more? There's different ways you could go about that. And if you want to know how it was done previously, you would look at footnote 8. Oh, we have more. Sorry. The effect that disclosure may have upon persons who have been given such information and whether they did so in reliance that their identities would not be disclosed. So they kept information on record, but they did it with reliability that their identities would not be disclosed. Then there might be a record for secreting the document. The extent to which the agency's self-evaluation will be chilled by the disclosure, whether any findings of public misconduct have been insufficiently corrected by an investigative agency. So you have findings of public misconduct, but it hasn't been corroborated by an investigative agency or corrected yet, right? Corrected meaning, I guess, there were errors in it. So you can't release this until it's been corrected. Now, look at this. Findings. Now, see, sometimes I've found out that a poor esquire will misuse something like this. Let's say they're working with a public official, and they'll somehow try to say that findings of public misconduct. And they'll say, oh, it's public official misconduct, but it doesn't say that. And you'd have to very clearly object and point that out. Whether an agency disciplinary or investigatory proceedings have arisen that may be circumscribed by the citizen's asserted need for the materials. So if by, you know how this goes, FOIA requests for body cams. The purpose for which the documents are sought, as whether confidentiality claim is premised upon a purpose which tends to advance or further a wholesome public interest or a legitimate private interest. So it's a purpose for which the documents are sought is whether it's a confidentiality claim is premised upon the purpose which tends to advance or further a wholesome public. So boy, that's in this case here, I'm sure, 22. There's one other one to check out here too is 20 and 22. So 20, so all these are this case, it behooves us now to check this case out. Lloydman versus Kimmelman, now is in New Jersey, 1986. And 22 is a matter of New Jersey Firemen's Association obligation to provide relief applications under Open Public Records Act, New Jersey. Wow, 2017. Whew. Good stuff. Under a good cause balancing test. So this is what we're doing right here. You're learning, I mean, a lot of people go and they go to law school to try to learn what we're learning right here. And I'm sure anyone here that can add 1 + 1 can figure this stuff out. Under a good cause balancing test, there is a strong presumption against entering an order of confidentiality, the scope of which would prevent disclosure of information that would otherwise be accessible under a relevant Freedom of Information law. Under a good cause balancing test. Nice. So there's a good cause balancing test you'd check under here too. Let's look at this. Reminder, another beautiful thing with American jurisprudence. We need to be prudent when we're trying to practice law, right? So administrative regulations bestowing confidentiality on an otherwise public document. Bestowing confidentiality on an otherwise public document. Administrative regulations. Although not dispositive of whether there is a common law right to inspect a public record, should nevertheless weigh heavily in the balancing process as a determination by the executive branch of the importance of confidentiality. So, 24, let's see what that is really quick if we can get a little insight into this. Camden City Public Schools District, New Jersey. Years at 2017. Certification granted in part, certificate granted in part, and 2019. Any more to that case? Okay. All right, so 2019, Camden City Public School District, New Jersey. So those are administrative regulations. Remember the administrator, right, of the trust. have regulations bestowing confidentiality on otherwise. So if they're the ones responsible for it, have not dispositive of whether there is a common law right to inspect a public record. So it's not going to take away your public right, should be weighed heavily in the balancing process. So in this process, we're going to consider these administrative regulations bestowing confidentiality. Doesn't mean they can win out, but they get to weigh, and they actually get to weigh heavily as a determination by the executive branch of the importance. So interesting stuff. This stuff gets so juicy right here. I mean, the stuff I've learned tonight, and I hope you all have too, is really just opened my mind to the public's right to public records, the right to copy or photocopy public records. It's a very short section, guys, so pay attention. The right of access to and inspection of public records commonly carries with it the right to make copies. The right to inspect may also include the right to photograph the records. And that's 3. District 2009, So the right of access to and inspection of public records commonly carries with it the right to make copies. So this is commonly, it's may include, so, but consider this. When we're saying may and commonly, and they're going to say against it, they have the burden of proof of why it's an exception to what may, or better yet, commonly carry. So we have a lot of different, a lot of concepts here. Say cheese to all the public records now. We could look up some of these case laws here. And they're current, 2018, 2009. People versus Zimmerman, 2018, Illinois. So if Audit Them has the Illinois, see that's 2018. I don't know if you have one that new. If you do, you can check it out and look at that case. Conditions and restrictions on right to inspect public records, fees or costs. This is going to be fun. The right of access to and inspection of public records is not absolute or unrestricted and may be subject to a reasonable time and place restrictions on the terms of access and reasonable rules and regulations as to when, where, and how the inspection may be made. Courts retain inherent authority to consider any conditions necessary to retain the integrity of a record and its chain of custody, as well as other equitable factors, such as the need for testing and administrative burdens. So the right of access is not absolute or unrestricted, may be subject to a reasonable time and place restrictions on the terms of access. That's 3. That's Lafgas versus New Jersey Turnpike Authority, 1998. And reasonable rules and regulations as to when, where, and how the inspection may be made. That's number 4. And that's State X versus versus O'Connell, 67. So we got a good held case right there. Courts retain inherent authority to consider any conditions necessary to retain the integrity of a record and its chain of custody. They have inherent authority. So automatically, if a court wants to consider any conditions necessary to retain the integrity of a record, they already have an authority to do that inherently. It doesn't need to be proven. And its chain of custody. So you could move a court to consider conditions necessary to retain the integrity of a record, and they already have the authority to do that. And the chain of custody. Get that? The chain of custody, as well as other equitable factors, such as the need for testing and administrative burdens. An inspection of public records may be subject to a reasonable fee for copying the record or the direct costs of duplication. And that's 6 and 7, Gross versus 2020. Missouri, Ohio 2020, Doyle versus City of Burlington, Vermont. A lot of cases here. Oh, look at this. Cheyenne Newspapers Incorporated versus Board of Trustees of Laramie County School District Number 1. Lawyers Guild, San Francisco Bay Area, Chapter for City Hayward, 2020. Oh gosh. We haven't gotten there yet, did we? Yeah, direct cost of duplication. So there we go. Very current stuff right here. An inspection of public records may be subject to a reasonable fee for copying the record. Not just reasonable fee, it's a reasonable fee for copying the record or the direct cost of duplication. The right of inspection itself, however, is not to be conditioned on the payment of a fee unless a reasonable service charge for inspection is warranted by the nature or volume of the request requiring the extensive use of information technology resources or extensive clerical or supervisory assistance. Footnote 9, Trout versus Booker. That's Florida 4th District of Appeals, 2016. In other words, fees for custodial review of requested documents are limited to disclosure requests that are extraordinary in some manner and are not generally charged for a review of requested public records to determine the right to disclosure. That's Parish of Ascension versus Wesley. It's Louisiana Appellate 2019. Great stuff here, guys. Tacos. You're bringing tacos, we'll have a conversation, but we need the tacos first. So let's look at this observation. A citizen does not have the right to obtain public records free of charge in the form desired when they are readily available in another form. Citizen does not have the right to obtain public records free of charge in the form desired when they are readily available in another form. So do you see this? So they can only charge you if you want a form that it's not otherwise available in. And that's 11 Mayo versus U.S. Government Printing Office, 1993. Oof. Okay, so even in the absence of any specific restrictions, the right to inspect public records implies that those exercising it will not take possession of the registry or monopolize the record books so as to unduly interfere with the work of the office or with the exercise of the right of others, and that they will submit to such reasonable supervision on the part of the custodian as will guard the safety of the records and secure equal opportunity for all. 1960, Ohio State. Subject to these limitations, however, records that are in the custody of public officials and have been designated public records by law are generally open to anyone at appropriate times. So what are the appropriate times? You guys have them open. Records that are in the custody of public official servants, POSs, and that have been designated public records by law are generally open to anyone at appropriate times, to anyone. Yeah. So what we got going on here? Let me take a quick break and look at the chat. Archangel for Truth. What's Archangel for Truth talking about here? Yeah, whatever. He's just joking around here about the photos. We do quite a bit. All right. So, yeah, I mean, if we could always do a panel, we could do one later. We could do one after this stream if AT is up to it. I'd want to take a break after this because we've been here just about the 2 hour mark. We're about to take a break, I think. We could always do another live stream in a half hour, an hour or something. Maybe take a half-hour break if AT wants to come on, and we could go through a little bit of a roundup of what we went over today and just have a little back and forth discussion on this. Have a little dance break in between. Yeah, I could throw some music on if you want, and we could just actually be great if we could get LA Spike to pipe some music on through. I could restream his channel right through here if you wanted to. We could have two choices to go to and come back here when it's done. If AT wants to come on the panel, let me know in the chat. And I'm gonna see where we're leaving off of here. Remedies to enforce right to inspect public records. This is gonna be great. The mandamus, because see, we're gonna get down a whole nother rabbit's hole with this section, and it's section 20, and this is a great place I think we're gonna be leaving off for today because we covered a lot of ground, guys. I can't believe y'all stick with me this whole time. And what we went through here is going to put us a cut above about everybody else out there talking about public records or trying to access them. It's going to make it so much easier when you're dealing with resistance, or how about going to get the records you need. All right, audit them. So let's see here. Let's just restart the stream in a half hour. That's fine. We could just, if anyone goes to LA Spike, let me see. I'll put a link to LA Spike if he wants to see. Not set up. No, okay, never mind. That's good enough. What we're going to do is I'm going to set up a new live stream. We'll come back on in a half hour, and we'll continue from right here. And let's do it. We'll have a quick little roundup discussion with Audit Them. He has some pretty good applications that he's done in the field with this. Maybe we'll review some portions of his videos too while we're doing the discussion. And yeah, let's do it. Let's keep this discussion going, guys. This is great. I really appreciate it. And I'm gonna sign out with some music here, and then we're gonna come back in a half hour. Look for the notification, or just check back in a half hour, and we'll be good to go.